You guys were the parents. It's all your fault.
The last thing about this figure out.
I'm getting
Civilization.
Exactly.
we are the older civilization. We better step away. Older than the Romans.
I know you can't do anything about it.
I don't think I need one. Is it on?
It's like wearing t-shirts. This Porsche, there's like a bug out.
Where's the actual? Oh, yeah. Pen. Okay. I can turn it right there, so if it, is that okay? And I'll try to project, and just in case I don't, it'll pick it up on that. Perfect, thank you. Not there. Like I would have to.
I know them already.
I shortened it because I was practicing it. So I cut out.
Oh yeah, no one's coming.
I always say this.
God, I wish I had more time.
I'm in the when I see
But he's a right and he's silly. It took a while to figure that out. No, really. He could act like one, but it took him a while to realize he's actually a good person. I mean, this guy. No, it's the beginning. It was just pure evil.
and did that, I guess.
And now he's your friend. I don't know what I would. The whole law school experience would be different with that. Put it that way. That has been a huge shitless last semester.
I call you Anne. It's really cute. I like Anne. Can we meet? Please? Can we meet? And her. Thank you. What else do you need? My pen. You can use it. No, I don't need it. You don't know? Oh, we got an email about it.
Can I remove the file?
The email we got was from Marni.
Do you want me to designate candidates and your hours? And whoever else. But, I guess we can Why didn't you go to the reception before you started? And then the board members as well.
Yeah, I was just spot on.
I know you were like clutching it. I was like,
You're good? Are you sure? Yeah.
Just keep it back on there for.
You ready? I just want nobody to know.
oh, is that my water? No, it's mine. I handed it to you. No, cold. Unless mine is in my bag and I was holding your water.
No, it's probably yours. I threw mine away. So actually, I have a story about you though. So I read. Oh no.
Yeah, this is mine because it's the bottom. Wait, what?
Are you kidding me? Everyone raised their hand and said specific performance.
Yeah, just make it fit there.
Teaching. And I said, why do I want to get different stuff? He said the difference. He goes, well, he was online in a small section. I just want to make clear.
We gotta meet him.
No.
I know. Okay. I'm good. At the end. I'm going to call. I'm just over there. Hey. It's cool. So excited. So what did you do? Just should have made signs. Why would you go to class? Like, did she get it out? Yeah, if he sat downstairs, there would have been nothing. Well, now we can do. Oh, because if he sat downstairs, there would have been nothing.
Or even have teachers. Like they're just space.
You could have even sat in the library. You could have even signed him into the lab.
Alright, guys, can we try to keep the stroke empty? Alright. If we don't have to see it, it's fine, but now. Okay. Thank you.
No, you're not going to say good. Miss Weiner's parents and uncle are.
That's fine. Yeah. There be it. Yes. You got to sit in the center. Oh my God. What's wrong? What's going on? That was easy. He's not going to don't be bad. I know. What? It's going to be for like 5 minutes. Go right ahead. Anyway, you want something downstairs? You're not going to make me stay with That would work great if they're
Nice of sharing what Professor James said, right?
I think she will pick her level because then she has everything. Like, if she's asking us about actual things, I think she's and then it's like, what if, let's say it's like 30 years old, I have to stick them all in one
some in my bag, I think.
Is there a beautifully American name on there? There is. They made me
Hide me.
and I am Director of the Student Advocacy Programs, and I welcome you all to what I think is going to be an extraordinary event. And I want to say congratulations to our two finalists, Marni Weiner and Tom McGowan. And this evening special and shows you what a unique group we have here and what a family we have here is Tom is a first-year student. His sister is Kelly McGowan, who's a second-year student, and she isn't here tonight, which you wonder why, because why would she be here supporting her brother? Well, Kelly is part of our ABA National Moot Court team, and she is competing. So we have siblings competing in moot court competitions, and that's what we like to see here at Hofstra. And yes, it's very exciting. And it's also very exciting because we have a wonderful group of students who form our moot court board and who have put together not only this event, but our entire student advocacy moot court program. I'm going to turn it over to Eleni Cintron, our president.
Hi. You guys make me feel famous. It's awesome. So, good evening and thanks for coming tonight. I want to congratulate the two finalists once again. This is the closest competition we've had in 2 years that I've been here. And yeah, it seems like it's been like decades because it's law school, but it's the closest competition we've ever had. So you guys have a lot to be proud of, and congratulations on your accomplishment. I also want to take a brief moment to thank Cindy Thomas and Zhenya Krasnov, our managing editors, along with associate editor Melissa Shepelou, who helped draft the problem. for tonight, along with their casebook editors, Ting Ting Liu, Hanaya Golson, Brian Boxler, and Damian Racanelli. You guys did an incredible job putting all this together, and thank you for your diligence. I really appreciate it. I also want to take a moment to thank Meryl, our Director of Competitions, along with Lauren Matty, our Director of Business Affairs, and our advisor, Professor Barbara Barron, for making this possible tonight. Thank you very much. And before we begin and get into this amazing competition, I'm sure it's going to be, I want to take a moment to briefly introduce you to our panelists and judges. Thank you guys for joining us tonight, taking the time to be here. We'll begin with Justice Sally Manzanet Daniels. Judge Manzanet Daniels was born and raised in New York City. She attended Hofstra University School of Law on a full scholarship, where she served as the first president of the Latino Law Student Association and graduated in 1988. As an alumni, she co-founded and served the first chair of the LASA Alumni Scholarship Fund, which continues to raise thousands of dollars for aspiring Latino lawyers. Judge Manzanet Daniels began her legal career with the Legal Aid Society in the Bronx as a criminal defense practitioner. In 1999, she was elected as a judge of the Civil Court of the City of New York in the Bronx. And in November 2001, she became the youngest justice of Hispanic heritage ever elected to the New York State Supreme Court. In October 2009, Governor David Patterson appointed Judge Manzanet Daniels to the Appellate Division, First Department, thereby making her the first Latina justice in the history of New York State to serve on that court. Thank you for being here tonight. Next is District Attorney Kathleen M. Rice. Kathleen Rice was born and raised in New York and received her Juris Doctorate from Touro Law School in 1991. Ms. Rice began her career as a prosecutor in the Brooklyn District Attorney's Office, where she was promoted to the office's elite homicide bureau, where she successfully prosecuted dozens of murder cases. Kathleen Rice served as an Assistant United States Attorney under Attorney General Janet Reno in the United States Department of Justice, Philadelphia office. And in 2006, she became the first female district attorney in Nassau County. Ms. Rice is the third Vice President of the District Attorney Association of the State of New York, a member of the New York State and Nassau County Bar Association and National District Attorneys Association, a member of the Board of Governors at Touro Law School, and a board member of New York Prosecutors Training Institute. Thank you for being here tonight. District Attorney Thomas Foda was born and raised in New York. He received his Juris Doctorate from St. John's University School of Law in 1996. Mr. Spoda began his career as a prosecutor in Suffolk County District Attorney's Office and became the Suffolk County District Attorney in 2002. Since taking office, he has established a Government Corruption Bureau, an anti-gang unit, and a unit devoted entirely to prosecuting violations of labor laws and insurance crimes. Mr. Spoda's indictment of 12 Suffolk residents who utilized a file-sharing program to spread child pornography led him to being called to testify before the United States Senate Commission on the Judiciary in 2003. Mr. Spoda has served on the Board of Directors of the Suffolk County Criminal Bar Association and was an adjunct professor at Suffolk County Community College. He also served in the United States Marine Corps and the Marine Corps Reserve. Thank you. Next, Professor Lawrence Kessler. If you didn't have him for reports, I'm sure you'll see him around at some point in your career here at Hofstra. He received his Juris Doctorate from the Columbia Law School in 1967. After graduating from law school, Professor Kessler clerked for Judge Edward McLean, United States District Judge for the Southern District of New York. He then became a trial attorney with the Federal Defender Services of the United States District Court in the Southern District of New York. He is a former senior trial attorney for the Legal Aid Society, Federal Court Branch, and has actively practiced law as a criminal defense attorney in the Federal District Courts for more than 25 years. Professor Kessler is a national expert in the field of trial advocacy training. He is the director of the National Institute of Trial Advocacy's Master's Advocates Program and the co-director of the National Institute for Trial Advocacy's Northeast Regional Program. Thank you, Professor. Next, we have Douglas J. Gibb. Mr. Douglas Gibb received his Juris Doctorate from New York University in 1971. Mr. Gibb is a partner at Ruskin, Moscow, Kolchacek, where he is chairman of the firm's litigation department and member of the employment law and corporate governance practice groups. He is also the chair of the firm's practice management committee. Prior to joining Rescue Moscow Baltic, Mr. Gibbs is the executive director of the Legal Aid Society of Rockland County. He has extensive experience in trial and appellate advocacy in both the state and federal courts, as well as substantial experience in alternative dispute resolution. Mr. Gibbs is a past president of the Nassau County Bar Association, a fellow of both the American Bar Foundation and the New York Bar Foundation, as well as a member of the Federal Bar Council. Thank you very much for being here today. I'm going to turn it over to Ms. Elder. Thank you.
Thank you all for coming here tonight. Before we begin, I just want to thank a couple of additional people. Marcel Hernandez, Professor Barron's assistant, Caitlin McAllister and Anna Pellegrini, who helped with all the background stuff, everything that was needed for the emails that were sent out, the parking permits for the judges, like all the technical stuff that happened behind the scenes. And most of all, I'd like to thank the Moot board for all the work they've put in through all the rounds in order to get us now here to this final round. In particular, I'd like to thank a couple of people who helped me personally run this competition above and beyond. Michal Avadia, Kelly McGowan, Damien Raffinelli, Sivash Mari, and Paula Jerry. Thank you very much. I hope you all enjoy the final round tonight and appreciate the work that the competitors have put in to get to this point. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
You're reserving time for rebuttal?
Yes, Your Honor.
You may proceed when you're ready.
Madam Chief Justice, and may it please the Court, my name is Marni Weiner, and I represent Petitioner Sheldon Foxworth in this matter. Petitioner requests 1 minute for rebuttal. Thank you. Your Honors, the decision of the 14th Circuit Court of Appeals should be reversed for the following 2 reasons. First, in order to determine the constitutionality of a search of a single-purpose container, the objective layperson's perspective should be used. Second, in using the layperson's perspective, this Court should find that this tennis racket case is not a single-purpose container. As to my first point, the objective layperson's perspective should be used to determine a single-purpose container. Your Honors, the Fourth Amendment has 2 requirements for a reasonable search and seizure. The first is probable cause, and the second is a warrant. This warrant must be given by a neutral, detached magistrate, which was stated by this Court in Coolidge v. New Hampshire, because officers are often in the competitive enterprise of ferreting out crime, and therefore this neutral magistrate will protect privacy rights of citizens and protect citizens from a subjective bias of police officers. Likewise, a person must have a reasonable expectation to privacy that society recognizes. This was also stated by this Court in Katz v. United States, protecting the layperson's perspective and proving that society must recognize a reasonable expectation of privacy. Your Honors, this layperson's perspective can be promoted through general social norms, which was stated by this Court in Robbins v. California, and further elaborated in United States v. Gust. Where the
Counsel, we entrust our law enforcement officers with authority and with the responsibility of ferreting out crime. And my question is, if law enforcement officers are trained to perceive whether someone is carrying contraband, why shouldn't we rely on the judgment that we finance and educate them to have to permit a search like this when it is immediately apparent to a trained officer what the contents were?
Your Honor, the officer's perspective should not be used in the instant case, as stated in United States v. Miller. An officer's training can still be used for probable cause, but probable cause is not enough to ignore the warrant requirement when a container is not of single purpose. This container was not single purpose for the carrying of antique firearms and therefore not subject to search without a warrant.
Can I ask a question? I'm sorry.
Please go ahead.
It says here in the circuit dissent that the record before this court is devoid of any evidence indicating that a layperson would be able to determine the contents of the tennis racket based merely upon experience. But if there's no testimony of a layperson, as there was not in this particular case, as to what he or she observes, how could we ever uphold a warrantless search?
Your Honor, a layperson would not have determined that this container contained contraband and therefore promoting the privacy rights of citizens over officers who have a subjective bias.
But what would we, you're asking us to accept a layperson's observations, but we don't have any layperson's observations. Who's going to make the determination? Us? Or an officer who has, as this justice just mentioned, training, experience? You're asking us to do that.
Your Honor, yes, the layperson's perspective is promoted through general social norms, expectations of privacy that every layperson uniformly has. Therefore, when a layperson looks at a container, they should be able to determine whether or not its incriminating nature is apparent, as was not the issue in the instant case. Because
we know that with the ever-increasing drug trafficking and gun trafficking that occurs in our country, that criminals have found incredible ways of secreting their contraband. So why should the court not allow the expertise of officers that goes beyond the general layperson's knowledge of how this contraband is secreted?
Your Honor, the layperson's perspective will protect privacy rights of citizens because, as you stated, if an officer can use their training for probable cause, it must stop at the warrant requirement because this container is not single purpose, which brings me to my second point, that this tennis racket case is not a single purpose container. Therefore, the officer was not...
Isn't it akin to a single purpose container, as the Commonwealth versus Kendrick said?
Your Honor, this tennis racket case does not proclaim its contents as the case did in Commonwealth v. Kendrick. Therefore, this court stated in footnote 13 of Arkansas v. Sanders that when a container proclaims its contents, they become immediately apparent to the observer. The owner loses their rights of privacy with respect to that container.
But that's exactly what this police officer did. It was immediately apparent to him what was inside this container.
And he testified.
And he was right.
And he testified to a certainty, based upon his experience and the training that he had gotten, as training from an antique firearms expert, that 72% of the time they have apprehended somebody, it was in such a container, and that the container would be, the characteristics of the container would be such that it wouldn't even look like a tennis racket. And in this case, it didn't look like a tennis racket. The head, it was nothing.
Your Honor, the bulge in the tennis racket case was too ambiguous. This tennis racket case it was zipped shut. It was black and opaque. Therefore, an indistinct bulge is what was present. Likewise, the 72% statistic was of the 100 guns recovered. 700 guns are missing, and these 100 guns cannot prove the basis to determine that a tennis racket case is now a single-purpose container.
Did the officer here describe the bulge characteristics such that it would change the level of intrusion permissible here, so that, did he describe that the bulge appeared to be the butt of a gun or such type testimony here?
Your Honor, the officer testified that there was a distinct bulge, but it would be too indistinct for a layperson to determine that there was incriminating evidence inside, as the single-purpose container exception requires.
What would you expect the officer to have done instead? Can't arrest the guy, let him go, see him another day?
Your Honor, the officer should have gotten a warrant in the instant case. His probable cause determined that he can then get a warrant. The search of the container went too far and invaded the defendant's privacy rights with respect to his container.
Does the fact that when stopped, the petitioner, defendant, acted nervously, uncharacteristically so for the situation, so as to give the police officer further suspicion that his hunch, for lack of a better word, is accurate.
As well as wearing clothing that were inappropriate for anybody to come to play tennis and on his way to an airport.
Your Honor, those external circumstances are exactly why a police officer's perspective is subjective. A layperson's perspective, as stated in United States v. Miller, solely looks to the contents and the appearance of the container.
Counsel, you just answered a question before from Judge Kessler and said that you thought that the appropriate course of action was for the officer to seek a warrant. Would the officer have obtained the warrant?
The officer could have, yes, Your Honor.
Well, and the requirement to obtain the warrant would be reasonable cause, correct?
Probable cause.
Probable cause. And so, if you concede that there was probable cause for the issuance of the warrant, what harm is there in allowing him, the officer, to exercise his judgment, which you concede would have been supported by the court, and dispensing with the warrant requirement because he wouldn't know where to find this perpetrator?
Your
I'll
Honor,
allow you to answer that question. Your time is up.
thank you. Your Honor, can you repeat the question, please?
If you concede that a court would have found probable cause to issue a warrant, then the officer had probable cause to search without the warrant. And no harm was done in this search.
Your Honor, harm was done. An officer's probable cause in the instant case has subjective biases, including the external circumstances of the container that the Fourth Amendment warrant requirement protects. Your Honors, for the aforementioned reasons, this court should reverse the decision of the 14th Circuit. Thank you.
Thank you.
Madam Chief Justice, and may it please the court. My name is Thomas McGowan, and I represent the respondent to the United States in this matter. Your Honor, the decision of the Court of Appeals for the 14th Circuit should be affirmed for the following two reasons. First, in the interest of public safety, the officer's perspective is the appropriate standard to govern in the single-purpose container exception to the warrant requirement.
Didn't he say that he wasn't concerned about his safety or the safety of anybody else because it's an antique firearm and it took a long time to load? What was his safety? He testified, I believe, that he wasn't concerned about his safety.
That's correct, Your Honor. However, the single-purpose container exception does not require some sort of immediate threat or exigent circumstances. In fact, the question posed to this court in Arkansas v. Sanders was, absent exigent circumstances, were the officers required to obtain a warrant to conduct a search of petitioner's luggage. While this court answered in the affirmative, it specifically noted in footnote 13 that the answer to this question might be the opposite if the luggage was in fact a single-purpose container.
Why is this a single-purpose container?
Your Honor, this case, this particular tennis racket case, is a single-purpose container because, as this court stated in Arkansas v. Sanders, single-purpose containers are those containers that, by their very nature, support no reasonable expectation of privacy because their contents can be inferred from their outward appearance.
Counsel, would you argue in support of the officer's action if instead of finding the antique gun that he thought would be inside the case, he found a kilo of cocaine?
Well, Your Honors, what justified the search of petitioner's assault tennis racket case was that it reasonably appeared to conceal one of these antique firearms. Ultimately, given this reasonable appearance, ultimately, if the officer opened the container and did not find the gun, this would not have mattered. In fact, the First Circuit in U.S. v. Viata addressed this very issue. Your Honors, as this court stated in Finalists v. U.S., an officer is permitted to rely on his training and experience in order to draw inferences and make deductions that might elude an untrained person.
How is that different from a police officer finding a hunch without the requisite probable cause?
Well, Your Honor, in the case of single-purpose containers, and as this court stated in Terry v. Ohio, the officer must be able to point to specific facts and reasonable inferences that he drew from those facts that justify the search of the petitioner's container.
Well, the appearance of this particular tennis racket on that day, based on its configuration, could it have just contained a tennis racket and keys and a cell phone, perhaps?
It's possible, Your Honor. However,
So if it's possible, then it can't be the type of container you need it to be.
no, Your Honor, because this particular assault tennis racket case proclaimed its contents to the trained eye of the officer. Following the rash of stolen firearms, officers in Hillside have been specifically trained to identify just how these containers would look if they were in fact concealed.
And 72% of the recovered firearms have been hidden in tennis racket cases. Is that correct?
No, that's correct.
And do we also, you want the court to believe that 72% of the people who use tennis racket cases use them to transport stolen antique firearms?
No, Your Honor, the respondent's position is not that. It's that, in this one particular case, these...
Do I have the right to use my tennis racket case without fear of having the police accost me and open it when I am with the societal norm of using a tennis racket case to carry a tennis racket, or my gym clothes, or my school books, or anything else?
Yes, that's correct, Your Honor, but facts in this case were that there was a specific crime wave where criminals were commonly using these specific soft tennis
So
racket
does
cases.
that mean that a crime wave then means that the other 28% of U.S. citizens are not entitled to their constitutional protection when carrying a tennis racket?
No, Your Honor. As this court stated in Texas v. Brown, critical to the officer's perspective is a balancing test. Specifically, that the reasonableness of a particular law enforcement action is judged by balancing its intrusion of Fourth Amendment interests against its promotion of legitimate governmental interests.
So should our allowance of intrusion, should we require that it be something more than just the object itself, just the single object container, that it be coupled with additional observations that would raise reasonable suspicion and get us to probable cause?
Absolutely, Your Honor. In fact, as the Fourth Circuit in U.S. v. Williams stated, in addition to an officer's training and experience, the circumstances under which he finds a container may speak to the apparent nature of its contents. And in this case, there were compelling circumstances that spoke to Officer Oates and allowed him to conclude that the petitioner was in fact concealing one of these stolen antique firearms.
What were those compelling reasons other than the rash of crime in the area? Which I don't think is enough by itself, counsel.
Well, in addition to the 72% of these particular firearms being recovered from these tennis racket cases, when Officer Oates spotted the petitioner, he appeared extremely nervous, was looking over his shoulder, clutching tightly to the soft tennis racket container, and notably ill-dressed for a tennis match.
Well, but he may have been ill-dressed for a tennis match, but that doesn't mean that he was ill-dressed for carrying a tennis racket case, does it? I mean, aren't I entitled to know that when I walk down the street with a tennis racket case that has something in it, aren't I entitled to know that I'm sending a signal to the police, come and search, come and search? I don't want them rummaging through my dirty gym clothes. I have a right of privacy there. And counsel, you need to tell me why people like me carrying my dirty gym clothes can't have the protection of this officer going to get a warrant.
Well, Your Honor, he's not required to get a warrant because there are narrowly defined exceptions to the warrant requirement, and the single-purpose container is a widely accepted exception to the warrant requirement. Again, it goes back to...
Well, aren't most of the cases that have found a single container, aren't most of those cases gun cases or bricks of cocaine that are distinctly packaged in a way that clearly the officer's training and experience would be relevant. Aren't most of the cases
Well,
those type of cases?
not necessarily most of them, Your Honor. In fact, in Commonwealth v. Kendrick, which was brought up earlier, the court in that case upheld the search of what was a common film file because to the officer, based on his training and experience, he knew that these particular film files were often used to conceal and transport narcotics.
But the court didn't say that the film file was a single-purpose container. It said it was akin to a single-purpose container. So my question to you, counsel, is if there had been a number of arrests of people with tennis racket cases in which drugs were found, illegal drugs were found, and a number of arrests in which stolen guns were found, would this be a dual single-purpose container?
Well, Your Honor, it would depend on the extent to which the container proclaimed its contents to the trained officer.
Well, if a trained officer knew it was either guns or drugs, would it be a single-purpose container?
Well, it would depend, Your Honor, on whether or not the contents of the container were so proclaimed that he was able to identify as if the object itself were in plain view, even though it was within the container. So theoretically, he should be able to know, just by looking at the container, as is required by the single-purpose container, that what is in the container is what he expects to be there.
In almost every district court case that has looked at this issue, where the object is something that is used for a common purpose other than secreting contraband, like a guitar case, a violin case, all of those cases found no single-purpose container.
That's
So
correct.
how is this tennis racket, which to me is like a guitar case, how do you get around those cases?
That's correct, Your Honor, because those cases that you mentioned were hard plastic cases, whereas the tennis racket case in this matter is soft and proclaimed its contents to the trained eye of the officer.
Well, how about the Gus case that the petitioner relied on?
Again, Your Honor, it was a hard plastic case. So therefore, it could not proclaim its contents. Your Honor, I see my time is running out. Just wanted your question
Yes,
to
you may.
conclude. Again, it was a hard plastic case. It was not a soft container as is the matter here, that so clearly proclaimed its contents.
Well, didn't Gus also admit that there was a gun in the case? Didn't he admit that he had, that the case that he was carrying, when that police officer went into Gus' house, a passerby already had said there were shots being fired within the property that Gus owned. When the officer went in there, he heard gunshots. He sees Gus carrying a hard plastic case.
Which said Bushmaster on it, and we all now
And-
know how important that word is.
And Gus admits that there was a gun in the case that he was carrying. Now, they're relying on that case, the petition. What do you think about that?
Well, Your Honor, it wasn't necessarily a single-purpose container in the sense that it did not proclaim its contents to the trained eye of the officer.
But you're not telling us that the officer saw the outline or the shape of the revolver because the case was soft, are you?
No, that's
It was just a bulge that he saw.
that's correct, Your Honor.
That
But
was consistent with the revolver, right?
right, well, based on his training and experience, he had been trained to recognize such a shape inside the soft tennis racket
Okay.
cases.
Thank you very much, time is up. You have 1 minute to vote.
Your Honors, just one brief point addressing Respondent's argument. Respondent uses Ornelas versus United States, a case by this court, to use evidence for a police officer's perspective. Yet this court held that probable cause and reasonable suspicion by an officer must be reviewed de novo, therefore not giving a sweeping, dangerous deference to the officer's perspective. Thank you.
Excellent. The court will roll call deliberate.
the competition, when they come back, before they announce who the winner is, they'll give critique, so everyone can understand, you know, what works, what doesn't, what they did right, what we need improvement, so you can understand how pro competition works.
Now,
right, so before we get started with the critique and then ultimately announcing the winners, as a token of appreciation from the Moot Court Board to the bench for coming out here tonight, we have a little gift for them, so I'm going to go ahead and hand that out, and then good stuff. So, let's see, Professor Hessler. Mr. Svoda. I'll turn it over to the bench now for the critique, and then they'll announce the winners.
Okay, why don't we start with Davis?
So, I just want to make sure you're there. So it's Tom McGowan, right, and Marni. So Tom, my colleague just to the east, I don't know if he's going to abide by this too, but I am loath to say anything remotely negative just because so many people here want jobs in my office. I was going to say nice things, so here we go. This is incredibly hard, what you guys are doing, and I think that you both deserve a huge round of applause for actually just getting here to the finals from everyone. Isolated what the issues were. You knew the case law very well. You made very good eye contact. We were talking about one issue that I'll let the actual judge here talk about. But I thought you did a very good job. I thought you were very responsive. I thought to the questions and very good going back to what your argument was once the questions were done. So I thought you did a great job. And I do believe that you, Tom and I both agree that you have a tougher side, that's for sure. So Tom, I have to say to both of you, I don't know who taught you this, but you kept very good eye contact. You definitely got the more bruising questions. You had the easier argument, but you had a very good command of the case law. I thought you did a very good job of kind of going back, trying to get back, even though you were interrupted maybe more than Marni was. But you did a good job of going back to your argument. And I think that your command of the case law was good, even though I think your argument, as I said, was probably the more, the easier one to back. But I think that you both did a great job, and I'm not going to say anything negative, sorry.
Well, I'm not saying anything negative.
Let him, he's the big bad dog.
I also agree. I agree with everything Kathleen said, because certainly you, in my view, reading these cases, you had a far more difficult argument. It seemed fairly clear to me that this would have been affirmed by the Supreme Court. That's my thinking, anyway.
This one, yes.
Oh yeah, absolutely. It would have been a 5-4 decision, probably. Yes. But your arguments were great, and you did make good eye contact. And I thought the questions were pretty tough that were posed to both of you. It didn't fluster you. I probably, if I had been sitting there in my first year, I think I would have fainted. I think you did a great job, both of you, and you had a great command of the law. There were a couple of cases that we talked about. You knew the facts of the case, and that's terrific. And my congratulations for getting to this point. I think it's great, and what a great experience for both. Thank you very much.
I do think that you both did a terrific job, I sense that Professor Barron had something to do with your training because you have participated with her in some of these exercises, and I think that you learned the lessons that I've heard her teach both very well. Getting back to your argument, addressing the court, not fidgeting, What else is there? You know the list. You know the list. And it's not just a list for academic purposes. It's a list because it allows you to more effectively make your arguments no matter what they are. And you both did an excellent job. I have to disagree. You don't know whether I'm the dissenting opinion or the previous two judges are the dissenting opinion yet, but I think you had the right side of the case. And that's maybe why I gave Tom a little bit of trouble with questions, because I wanted that side to win, and I wanted to think that in our world that side would win, because I don't want anybody watching for my But you want both to be congratulated. You are, I don't know how many times you've done it, but incredibly poised, and perhaps the judge is going to say this because she's no doubt sees more arguments than I do. But I've spent my fair amount of time in appellate courts and watched a lot of people, and most of them are not nearly as calm and cool and collected as you are. I hope you've had that experience, and you will have that experience, and you will recognize how good your training has been and your performance has been.
I concur in just about everything that everyone has said so far, the both of you. The command of your case was superb. Eye contact, the physicalities of your presentation are perfection. You are ready for my courtroom. So in terms of that, I think the both of you were basically equal. I agree with the panel well, I agree with Justice Good down there that I wanted your side to win, but you did have the toughest case law to deal with. And so I thought that you had a higher hill to climb. And so I think I agree with him as well, that I think that's why you got some of the tougher questions. And I was impressed with how you handled them. You did not get flustered, you didn't let us get under your skin. And as many times as I tried to throw you off your game, you weren't bound. So superb job on that count. The one thing I wanted you to do differently, one substantive thing that I thought was problematic was you conceded that if it went to a judge, probable cause was present. And in this case, where reasonable suspicion was the issue, to say that if it went to a judge, probable cause would be present, like the judge said down at the end. So what harm was there? Okay. So, but other than that substantive argument, you nailed it. Okay. So, as a Hofstra alum, I am so proud. You guys were excellent, and you have much to be proud of. And so, after deliberation, oh, sorry.
I was hoping to be forgotten. 2 hours.
I'm so sorry.
Procedure, and I have to say, for a lot of you who have me, how come when I call on somebody in class, I don't get these answers? Both of you were terrific. I have to say that, in my view, and everybody has a different view, sometimes the questions that are asked create possibility for somebody to look really good, and if easier questions are asked, that possibility isn't there. But I really think that you all, in fact, beautifully, you use the case law and the facts in the answers to the questions. And the thing that's particularly impressive is that neither of you spent a whole lot of time thinking, which means that it's obvious you had prepared for just about everything you said. So enormously impressive. But if you're in my class, I expect answers.
collaboration with my associate justices, we have determined that the respondent is the winner.
Everybody ready?
Guys, pay attention now.
Are you ready? One more. All right.
Good luck.